Hi, I'm Jerry Sparks, President of AG Financial Insurance Solutions, and welcome to Risk Management Live. Once again, we have with us Rich Hammar, renowned attorney for the Assemblies of God, and just an expert in regards to risk management, renowned author, and we're just so glad to have you. And with this subject here, we're going to be talking about talking about gay marriage and employment discrimination in regards to sexual orientation. You can tell that we're not shy about staying away from the hard subjects. So getting into that, why don't you start with gay marriage?
Okay, well, Jerry, I received so many inquiries in recent years over this whole issue of gay marriage from pastors, from churches that are asking me, you know, can I go to jail if I refuse to perform a marriage between people of the same gender? Or what if my church refuses to allow them, a same-sex couple, to be married in our church? There's a lot of paranoia, I think, over this issue today. And I think it's important to recognize at the outset that people's views on these issues are very polarized. And I mean, that goes without saying, that a lot of people, a lot of religious people, a lot of churches, a lot of clergy in this country feel that people should be treated the same, equally, regardless of sexual orientation. And that, a lot of things flow from that, you know, that same-sex couples should be permitted to marry, and there should be no discrimination by private employers against people because of their sexual orientation. And so that's kind of one side of the spectrum. In fact, a number of churches and denominations in this country ordain clergy who are homosexual. Some try to limit it to non-practicing homosexuals. Some don't care. So that's one side of the political spectrum. On the other side of the spectrum, or may I say theological spectrum, you have many, many churches, clergy, church members who are just as adamant that homosexuality is a unique status, and because it's denounced and condemned in the Bible in unequivocal terms, and the definition of marriage is unequivocal in the Bible, and therefore clergy and churches should not be hosting or performing marriage ceremonies between people of the same gender. And churches should be free to discriminate in employment decisions on the basis of sexual orientation. So you have this diametrically opposed views with regard to these issues, and that makes it very controversial. As you said, we're not ducking the hard questions here in Risk Management Live. So let's talk about that first issue of gay marriage, and then I'll follow up by talking about employment discrimination in general. I think it's interesting to note at the outset that there are 12 states currently that have recognized same-sex marriage. In some of these states, it hasn't taken effect yet, but in 12 states, plus the District of Columbia, same-sex marriage either is legally countenanced or it soon will be. Those states are Connecticut, Delaware, Iowa, Maine, Maryland, Massachusetts, Minnesota, New Hampshire, New York, Rhode Island, Vermont, and Washington. On the other side of the divide, you have 6 states that have enacted legislation that defines marriage as a union between a man and a woman, prohibits same-sex marriage in 6 states. In 30 states, the voters have enacted constitutional amendments to the state constitution defining marriage as a union between a man and a woman, implicitly rejecting same-sex marriage. That's not by statute, but by amendment to the state constitution. So, in those states, a state court could not say that such a law violates the Constitution because it's in the Constitution. So that's what makes, I think, a constitutional amendment at the state level more effective than a statute, which any judge can say violates the state constitution or even in some cases federal. And as we'll see later, the United States Supreme Court is going to weigh in on this issue here probably within a few months. And if they make a ruling based on the federal Constitution, such as the Equal Protection Clause of the Fifth Amendment, if that is violated by state laws that prohibit same-sex marriage, then all of these 30 state constitutional amendments go up in smoke instantly, plus, of course, the statutes. So it remains to be seen. We'll come back to that topic here in a few minutes. I also want to mention the Federal Defense of Marriage Act, which was enacted by Congress back in 1996, which basically states that for federal purposes, in terms of federal law, marriage is defined as a union between a man and woman. 8 federal courts have ruled that that statute is unconstitutional. 5 of those are being appealed to the United States Supreme Court. And again, in this term, they should be rendering an issue on that issue, as well as the legality of same-sex marriage in general. The state of California, I didn't mention in our listing of 12 states plus D.C., because California is a unique state. In 2008, the California Supreme Court ruled that same-sex marriage is constitutionally mandated and certainly permissible in that state, that any attempt to the contrary would violate the state constitution. That was reversed by a public referendum known as Proposition 8 in about 2010. And so then the Proposition 8 was itself challenged, and a federal court in San Francisco, a federal judge, ruled that Proposition 8 was unconstitutional. Boy, whoever decides what's constitutional or not has a lot of authority in this country, obviously. And because you have these vitriolic divide, they're so polar opposites here. Everybody trying to interpret what the Constitution means. And so that Proposition 8 was deemed to be unconstitutional by a federal district judge in San Francisco. That was appealed to the Ninth Circuit U.S. Court of Appeals. And that court last year ruled that, agreed with the federal district court in San Francisco that Proposition 8 was in fact unconstitutional. So now this case has been appealed to the United States Supreme Court. And oral arguments were held in March. Of course, it's hard to divine what the justices are thinking, but some court watchers have surmised that possibly there were indications that several of the justices were maybe looking for a way out, a backdoor exit from this controversy, for them to duck the issue on making a nationally binding precedent here and pretty much kicking it back to the states to decide how they want to do. A lot of people have condemned the abortion ruling in Roe v. Wade back in 1973 because it took the issue away from the democratic process and it became a fiat or a dictate by 6 out of 9 Supreme Court judges. And as a result, we've had 40 years of social unrest in this country. And because I think a lot of people believe the voice of the people was ignored. You don't see that in many European countries where abortion rights have been advanced through legislation and more democratic processes. So I think the U.S. Supreme Court has, and I've seen some speeches by some of the current justices that kind of make me believe that that's the case, that there's a certain sensitivity to this argument, and that maybe it might be better for volatile issues of social policy, which are so, they cause such a difference of opinion, hostile difference of opinion, that perhaps those social issues should be best resolved by the electorate, meaning at the state level. So we'll see what they do. At this point, believe me, there's no way of knowing what the court is going to do. But the bottom line is, sometime this summer, probably, the U.S. Supreme Court will weigh in on this issue one way or another, and I'll return to this issue later. But what we do know now is that 4 state Supreme Courts have found same-sex marriages to be constitutionally mandated, certainly under state constitutions. I want to read to you excerpts from these opinions. These opinions, by the way, are well over 100 pages long each, and I've carved out just about 50 pages I'd like to read to you. No, I've carved out the essence of these rulings And so listen to this. Here's the California Supreme Court ruling in 2008 that was overturned by Proposition 8, which itself was overturned by a federal district court and the Ninth Circuit Court of Appeals. Here's what the California Supreme Court said. Affording same-sex couples the opportunity to obtain the designation of marriage will not impinge upon the religious freedom of any religious organization, official, or any other person. No religion will be required to change its religious policies or practices with regard to same-sex couples. No religious official will be required to solemnize a marriage in contravention of his or her religious beliefs. What is the translation? Clergy are not required, even if same-sex marriage is deemed to be constitutionally mandated, clergy cannot be liable for following their religious sensibilities and not choosing to participate. So, and then how about this? The Connecticut Supreme Court in 2008, at about the same time as that California ruling, said this: religious freedom will not be jeopardized by the marriage of same-sex couples because religious organizations that oppose same-sex marriage as irreconcilable with their beliefs will not be required to perform these marriages or otherwise to condone same-sex marriage or relations. However, because marriage is a state-sanctioned and state-regulated institution, religious objections to same-sex marriage cannot play a role in our determination of whether constitutional principles of equal protection mandate same-sex marriage. Again, clergy are not required to participate in these ceremonies, and churches are not. How about the Iowa Supreme Court in 2009? In the final analysis, we give respect to the views of all Iowans on the issue of same-sex marriage, religious or otherwise, by giving respect to our constitutional principles. These principles require that the state recognize both opposite-sex and same-sex civil marriage. Religious doctrine and views contrary to this principle of law are unaffected, and people can continue to associate with the religion that best reflects their views. A religious denomination can still define a marriage as a union between a man and a woman. And a marriage ceremony performed by a minister, priest, rabbi, or other person ordained or designated as a leader of the person's religious faith does not lose its meaning as a sacrament or other religious institution. The sanctity of all religious marriages celebrated in the future will have the same meaning as those celebrated in the past. The only difference is civil marriage will now take on a new meaning that reflects a more complete understanding of equal protection of the law. This result is what our Constitution demands. And then finally, the Massachusetts Supreme Court, which is the first state Supreme Court to address this issue back in 2003, over 10 years ago, said this: our decision in no way limits the rights of individuals to refuse to marry persons of the same sex for religious or other reasons. It in no way limits the personal freedom to disapprove of or to encourage others to disapprove of same-sex marriage. Our concern, rather, is whether historical, cultural, religious, or other reasons permit the state to impose limits on personal beliefs concerning whom a person should marry. So those are state court rulings. That the only state Supreme Court rulings, the four that I just quoted from, each one of which articulates the view that even though those courts were recognizing same-sex marriage as constitutionally mandated, it didn't mean that clergy were required to perform them contrary to their religious views, or that churches were required to host them contrary to their religious views. No court has said to the contrary. Now, what about the federal courts? Well, remember that Ninth Circuit Court of Appeals that affirmed the San Francisco District Court ruling in which Proposition 8 was found to be unconstitutional, said this. This is 2012. Marriage in the United States has always been a civil matter. Civil authorities may permit religious leaders to solemnize marriages, but not to determine who may enter or leave a civil marriage. Religious leaders may determine independently whether to recognize a civil marriage or divorce, but that recognition or lack thereof has no effect on the relationship under state law. Proposition 8 does not affect the First Amendment rights of those opposed to marriage for same-sex couples. Prior to Proposition 8, no religious group was required to recognize marriages for same-sex couples. Affording same-sex couples the opportunity to obtain the designation of marriage will not impinge upon the religious freedom of any religious organization, official, or other person. No religion will be required to change its religious policies or practices with regard to same-sex couples, and no religious official will be required to solemnize a marriage in contravention of his or her religious beliefs. So I think the interesting thing to note about this federal appeals court ruling I just quoted from last year, and by the way, this is the case that's now been appealed to the United States Supreme Court, and it will be resolving this issue as an appeal from this Ninth Circuit case I just quoted from. The interesting thing is the Ninth Circuit Court of Appeals said, based its ruling on the constitutionality of same-sex marriage and the invalidity of Proposition 8, was that it violated the Equal Protection Clause of the United States Constitution. Now, that trumps all state laws. It trumps all state constitutional provisions. So remember I said 30 state constitutions define marriage as a union between a male and a female and reject same-sex marriage. In one stroke of the pen, literally, this summer, the Supreme Court, all it has to do is agree with the Ninth Circuit Court of Appeals and say this is a matter of federal constitutional jurisprudence, that the federal constitutional guarantee of equal protection of the laws mandates that same-sex couples be given the same right to marry as heterosexual couples. If that's the case, then all 30 of these state constitutional provisions, all 6 of the state statutes are per se rendered unconstitutional in a single ruling. So we'll just have to wait and see. But I want you to understand that even if that happens, it doesn't mean that that clergy are going to be exposed to any liability, be that civil or criminal, for following their conscience and their religious tradition and beliefs. Those who choose not to perform these marriages are not going to be penalized for that. And churches that are theologically opposed to these marriages are not going to be liable for failing to host them. And then let me also mention this. The United States Supreme Court, in a series of cases, including the Kedroff case back in 1952, has given such broad expression to the freedom of religious organizations to operate without governmental intervention. Here's what the court said in one of these cases. Our prior decisions radiate a spirit of freedom for religious organizations, independence from secular control or manipulation, in short, power to decide for themselves, free from state interference, matters of church government as well as those of faith and doctrine. These are the kinds of cases that are going to be cited and raised before the court and have been in briefs right now in the same-sex marriage case. So that's why I believe that the Supreme Court, if it doesn't duck the issue on a technicality, is going to do what all these other courts have done, without exception, and give a broad expression to the religious freedom of both churches and clergy to marry or not marry based on their religious convictions. There's 3 conclusions I want to draw here with regard to this first issue of same-sex marriage. 3 things. Number 1, no minister is required to perform a same-sex or any other marriage contrary to his or her religious beliefs, period. Anything you've heard to the contrary is false. Number 2, no church is required to allow its facilities to be used for same-sex marriages in violation of its religious beliefs. There's a lot of confusion on these 2 points, but what I'm trying to do is present a rational view based on the legal precedent of where churches and clergy stand on these issues. And number 3, here's a hot issue. Do you need to change your bylaws to prohibit same-sex marriage? I don't think so. Not at this point. Maybe in the future, depending on what the courts start ruling, that may be necessary. But now I just don't see that it's necessary because of the broad expressions of religious freedom that have been given by every court that's addressed the issue of same-sex marriage. It's inconceivable to me in this environment that such a provision is going to be necessary for you to have such freedom. Let me give this analogy. I think you're all opposed to incestuous marriage. Well, have you changed your bylaws to prohibit marriages between a brother and sister or between a parent and child? That's incestuous. Well, no, we haven't done that. Well, why not? That's clearly prohibited in the Bible. Or what about, you know, you don't marry 10-year-olds? Do you have that in your Constitution? Why not? Or what about marrying those unequally yoked? People from different faith traditions or maybe no faith whatsoever. My wife, when we started dating, I was an atheist. And I'm just thankful that, that she didn't rule me out and reject me as a boyfriend. And it was through her wonderful, godly life and example that I was brought into the family of God and brought into a recognition of Jesus Christ as the Savior of the world. And my life was changed forever because of it. So I thank God, Jerry, that my wife, I'm not going to date this guy. This guy. But some people believe strongly, and there's scriptural evidence for this, precedent for this, that people unequally yoked, as Paul says, perhaps should not marry. And so there's a number of, what about polygamy? Have you changed your Constitution to say that? We're not going to let one man marry 10 women, or vice versa. Why isn't that in there? Well, the point is there's a number of marriages. Are you going to be sued if a polygamous, if a man says to pastor, I want to marry 3 women, and you say, well, I'm not going to participate in that ceremony. Oh, you're going to go to jail. No, we never even think about that because pastors have the right to decide who they're, well, I have 2 10-year-olds, they're in 4th grade, they want to get married. My daughter, when she was in 7th grade, she already had 12 proposals. One of them she broke up with, and she said, he just called me, Dad. He's sitting out in the front yard in the rain, praying that lightning will strike him because I. What drama amongst 12-year-olds. So, well, what if they wanted to get married? Well, you're not going to marry those people. Why? Is that in your bylaws? So you see what I mean? A lot of stuff we know. The bylaws isn't the place. The bylaws is a document containing rules of administration and governance, not your policies. That should be in a different document, such as a policy manual. I don't think it needs to be there. If you want to put it there, you go ahead. But again, where are you going to draw the line when it comes to some of these issues? You don't need to do it at this point with regard to any of these. Polygamy, incestuous relationships, marriage between children, and on it goes. Now, let's move on to employment discrimination based on sexual orientation. And I want to look at federal laws and state laws quickly. At this point, there's no federal law that prohibits employment discrimination based on sexual orientation by private employers. The EEOC has defined Title VII of the Civil Rights Act of 1964, which prohibits employers with 15 or more employees from discriminating in employment decisions on the basis of race, color, national origin, gender, or religion. The word gender has never been interpreted to mean sexual orientation, but the EEOC did so last year with respect to federal employees, not private employers. Okay, so and then you have the Employment Non-Discrimination Act, or ENDA, which has been submitted to most sessions of Congress now for about 20 years, that would ban discrimination in employment by private employers based on sexual orientation or sexual identity. That law has never passed, and it does contain a very broad exemption which says this: this act shall not apply to a corporation, association, educational institution, or society that is exempt from the religious discrimination provisions of Title VII of the Civil Rights Act of 1964. So again, even if that law is ever enacted, which I don't see that happening in the near future, it does have a broad religious exemption. Now, with regard to state laws, there's 21 states that have enacted statutes that prohibit employment discrimination by private employers on the basis of sexual orientation. None of these applies to churches. Why? For a couple of reasons. Number one, they have broad religious exemptions. And number two, many of these are amendments to more general employment discrimination laws that the state has enacted that are not triggered unless you have a specified number of employees, which typically is 5, 10, sometimes 15, and many churches are below that threshold level. But even apart from that, there are these broad exemptions for religious organization. Many of these laws ban discrimination on the basis of sexual orientation, not just in employment, but also in public accommodations and in housing. But again, the religious exemption applies. Some of these laws ban gender identity discrimination. We'll talk about that here in a minute. And many cities, I think it's well over 100, have city ordinances that prohibit employment discrimination by employers within the city on the basis of sexual orientation, in many cases sexual identity as well. So that's something to be aware of. I haven't done an exhaustive search of municipal ordinances, but you just want to, if you live in a larger city especially, that's something that might be worth checking out. And of course, we have the ministerial exception, which the United States Supreme Court recognized unanimously last year, which says that the civil courts are barred by the First Amendment guarantee of religious freedom from intervening or interfering with employment disputes between clergy and churches, ministers and churches. So that law, or that ruling, is very relevant here as well. So clergy who argue, I was not hired by this church because I'm gay, there's no way that case is going to be heard by any federal or state court because of the ministerial exception. Or I was terminated because I revealed my sexual identity. Or I was not hired because of my sexual orientation or sexual identity. I had a sex change operation. It's the ministerial exception is going to be a defense in all of these cases. Let me just conclude with one issue, Jerry, and then I want to ask you something. You've been kind of silent today.
Yeah, I have been.
And that is transgender discrimination. Do you know that 16 states plus the District of Columbia prohibit employment discrimination by private employers on the basis of sexual identity? As I said, ENDA covers it, the Employment Non-Discrimination Act, which has never been adopted yet. But keep in mind that these non-discrimination laws focus on employees, not volunteers, not members. Many churches have contacted me about this. We have a man that became a woman because of a sex change operation. Can she use the women's restroom? Did she have to go on women's trips out of town and sleep in the same bed with another woman, or with a woman? Boy, the questions I get. And I just refer them to Jerry. And so the point is, they're not employees, so they're not covered by these laws. They're members, and the courts have consistently ruled that churches have a right to define their own membership. Now, Jerry, here's the question. So we've talked about a number of potential theories of liability. Churches may get sued because they are perceived as discriminating on the basis of sexual orientation in employment decisions. Even though they may be exempt, you may have to defend yourself. And that can be costly. So a question that often arises is, does the church liability policy cover employment practices?
And actually, that's a great question. Most directors and officers liability, if you have directors and officers liability, there's an endorsement you could add into that for employment practices liability. And whether you have one or two employees, it is good to have minimal coverages. And it is very inexpensive to have employment practices liability. And the majority of the cost normally, as you mentioned, really comes from defense cost. And so actually I would suggest, as far as an insurance program is concerned, that they have not only directors and officers liability, but they go ahead and throw in the endorsement for employment practices liability.
And Jerry, let me add something here. My research of reading every case decided in this country pertaining to religious organizations for the last several years has shown employment liability, number 3 of all categories of liability. And so this is a very real concern for churches. And oftentimes they get sued for some employment-related dispute, discrimination, wrongful discharge, and they come to find out they get a no coverage letter. That's not covered under your insurance policy. They're shocked.
Yeah. It is an amazing thing. Probably 5 years ago, we would have never heard about employment practices liability or people suing their employer for wrongful termination. But as you said, in the last few years, people are willing to sue the church now and to sue religious organizations. Whether you sue a pastor because I'm suing this church because I was too old and they brought in a younger pastor. Or they wouldn't hire a female pastor and they have a male pastor. We're starting to see race discrimination, age discrimination,
disability,
sex discrimination, disability discrimination. One of the things that we also see now is moral discrimination. You want to talk about that?
Yeah, well,
a little
the
bit?
issue there, of course, is a church that terminates a 19-year-old female in the church preschool for being pregnant out of wedlock, but come to find out, 5 years ago, he had a youth pastor, male, that engaged in extramarital sexual relations, and he was just, disciplined but retained as an employee. The courts have said this loudly and clearly in recent years. Churches, you are free to impose your moral codes on your workers, but you must do so consistently and uniformly in a way that doesn't adversely affect a protected group, such as females, people over 40, disabled, etc. And so with a vengeance, you will see churches that are sued for enforcing their employment standards, and come to find out, you're going to be you're going to be compelled to prove that you have not acted discriminatorily in enforcing your biblical standards.
What's interesting is that moral discrimination really is not covered under employment practices liability, but as you said, you're not treating the males as you would treat the females, and you get into then sex discrimination. So, wow, tough topics.
So, Jerry, but the point is, employment practices is not covered under the standard liability policy.
Absolutely
So how
not.
does a church get it?
They need to add that endorsement to their policy. They need to have directors and officers liability and employment practices liability, and they need to add that to their policy.
I would agree.
So we're out of time again. One question, I'm going to ask you one little question here. If a church has a for-profit center, let's say a bookstore or a cafe, that is for-profit because they can't qualify for nonprofit and they're selling items, would that affect them because they now have a for-profit section versus a nonprofit? Has there been any case law on this so far?
I can't remember seeing a case on that, but I'll tell you, I think there's a strong case to be made that if this practice, a coffee shop or bookstore or whatever, has moved itself intentionally out from under the organizational umbrella of the church and has become a standalone for-profit corporation, I am not confident that the religious exemptions available to the church are going to carry over to that organization.
So as long as it is just as part of the mother company and comes under their umbrella still, it should be fine.
Well, it should be, but again, it's fact intensive. It'll be based on the facts of each case, and it's hard to make generalizations.
Yeah, well, and in today's society, things change, as we have seen with everything else. So it depends on the court cases and the interpretations also. Well, we appreciate your time, and thank you for joining Risk Management Live. We'll see you next month. Thank you very much.